Welcome to Probate Problems and Practical Solutions.
This is Probate Problems and Practical Solutions with Carly Whiteside, founder of Wren Law. Carly started Wren in 2023 as the first woman to solely own an ABS law firm in the U.S., bringing a client-first mindset to complex probate, guardianship, and trust administration issues across Arizona. My name is Kevin Rosenquist, and today we're tackling a difficult reality. What happens when grief meets conflict? Let's talk about family inheritance disputes and how to handle a problematic executor. Carly, welcome.
Hi, how are you?
I'm good. This is an interesting topic. I'm guessing you see some pretty interesting things in your line of work when families start to have issues. So let's start here. Why do inheritance disputes happen so often after someone passes away?
Yeah, we do see this a lot. My practice does focus on litigation. So a lot of what comes in our door is this exactly what we're talking about today. And I believe the reason that we see this a lot is Arizona is a state that I've mentioned in other, episodes where nobody's really from here. Everybody's kind of here from somewhere else, Minnesota, Colorado, Washington, like everybody comes here to get away from the snow.
Right.
And so what this does, it kind of creates a family dynamic where everybody's spread out. So maybe mom and dad are here, one sibling's here, siblings are in other states, maybe just one sibling's here and everybody's somewhere else. So when we have a lack of regular family communication and visiting, things can happen that kind of nobody knows about. And then when somebody passes away, that's kind of when the cat gets let out of the bag, because now we got to talk about things,
Now we have to actually communicate.
Yes. And this whole, I'll worry about it when it happens. I'll worry about it when it happens. Well, now it's happened. And, is there a will? Is there a trust? Is there nothing? What does that mean? And so that's really where I see the issues come from, is just nobody's in constant communication. Nobody's around. Maybe people have kind of split off. And so that's the family dynamic that almost always leads to some kind of conflict.
Are there certain red flags that you see that you feel will signal that probate might turn into a full-blown family feud?
Yes, unfortunately, the two dynamics we see the most that typically lead to litigation are a parent that's on a second or third marriage with typically a spouse that's maybe younger, like 10, 15, maybe 20 years younger. And it's a recent relationship. Maybe they're only married 3 to 5 years. And so, the trust got changed. Maybe it was in place for 20 years. And then this new spouse comes into the picture and they go in and amend it. Well, that's not usually something that gets broadcasted. Most parents don't tell their adult children, hey, I know I just met this new person and you're my children, but now they get most of it and you guys just get a little. This usually comes out after they've passed. And the new spouse is typically the personal representative if it's a will, or trustee if it's a trust. And then the kids get a copy of it then after passing and basically get the bomb dropped in a piece of mail. The second dynamic that we see where we know we're going to have an issue is when there are multiple siblings, but one sibling lives with mom or dad or both, and the other siblings are out of state. And usually this sibling is the one to kind of worm their way in. Maybe they've always kind of lived off mom and dad. Mom and dad have kind of, always kind of taken care of them, as it says. And so unfortunately, they have the ability to kind of sequester mom and dad from the other siblings, maybe limit contact because they don't necessarily know. And that's usually the instance where we see there's a very recent will that gives everything to one sibling and the other ones are completely disinherited. Or there's some kind of deed that gets recorded on the house that gives them the house. So those are the two dynamics we see the most, where we kind of know, okay, we're going to have a problem. Depending on what happens, it could be a big or a small, but we are going to have some kind of issue.
These are things right out of movies or TV.
It is.
Seriously.
I do joke that my job is much more reality TV show-esque than it probably should be.
I can see that. How much power does an executor or personal representative really have? Like, what happens if that person mismanages the estate or I don't know, tries to cut people out?
So the personal representative in Arizona is similar to an executor. It's the same thing. It's just called something different. An administrator, depending on what state you're in, they're going to have different words. But in Arizona, we call it a personal representative. And they are empowered by the courts here. And so they have unfettered discretion when it comes to kind of liquidating assets, moving assets around. They are still held to what's called a fiduciary standard, which means they have, a duty of care to do the right thing and to do the correct thing, whether it be follow the terms of the will, or if there's no will, follow the Arizona intestate laws. So I don't want people to think, well, they have court powers, there's nothing I can do. Absolutely not. Court powers and authority does not excuse bad behavior and illegal activity of stealing from the estate, moving money around, giving themselves things. A lot of what we see with that is, well, the person that passed away, mom, dad, sibling, oh, well, they told me before they died, I get this. In Arizona, unless it's written down, it didn't happen.
Mm-hmm.
And so that's usually where we kind of see some issues of, well, I already transferred the car because mom and dad said I could have it. And we're like, it wasn't written down, give it back. So they do have authority in those ways to, liquidate assets, close bank accounts, move money. But there are mechanisms in Arizona that we can basically tap into when there has been a mismanagement or an issue for the courts to step in and basically say, hey, you're not doing the job you said you were supposed to do. Fix it or we're removing you. The courts don't really give somebody an opportunity to fix things because a lot of the people that are personal representatives, they've never done it. They're not professionals. You nominate a family member.
Mm-hmm.
You're just picking a lay person, a random person to say, do this job. And so I will say a lot of the times I do see people make mistakes and the court's aware of that. And especially if they don't have counsel, the courts will give them a little more leeway, which can be frustrating for other family members because they said, well, they clearly did it. Yes, but the court's going to tell them, here's your opportunity to fix it. If you don't, we're going to move to the next step.
What about your scenario that you gave before about the younger second marriage, the younger person, the younger woman, whatever, and then the kids are blindsided? Do they have any recourse in that situation, or are they pretty much SOL, if you will?
Unfortunately, the answer is a lot of the times you're out of luck. There's a couple of factors that the attorney will look at to determine viability of basically you're saying a claim of undue influence, which is where you're saying this person came in and kind of worked on this person and convinced them to make a change. Maybe they didn't necessarily want to make a change. So they kind of use their influence, their personal relationship to kind of sway their opinion. The couple factors that attorneys look at, especially Elizabeth, is when the change was done. So if this was done a few months before passing, okay, we kind of need to look at this, right?
Yeah, a little suspicious.
It can be. Some people do kind of realize it's the end and they get all their stuff together and kind of make a lot of changes very quickly because they realize, oh gosh, I've been putting this off and now I need to handle it. So we will look at the time. When was it done? What was going on at the time? Were the kids in touch with them? Had they been completely cut off? There's circumstances. The second thing that we look at is there a diagnosis of some kind of mental incapacity? Is there Alzheimer's? Is there dementia? Which would give them basically the inability to make changes because they don't have all of their mental faculties.
Right.
So those are the two things that we look at when those come through our door. And I will just say that an undue influence claim is extremely hard to prove. It's very nuanced. And in Arizona, we have a differentiation between testamentary capacity, which is making decisions about your estate, what you want done to your property, and then regular capacity, dealing with your finances. So it is possible for someone to not have capacity to deal with their finances, but they still retain testamentary capacity. And that is a very difficult conversation that we have to have multiple times with many different clients, potential clients. because our firm believes in giving it to people straight. And sometimes we have to tell people what they don't want to hear is, yeah, we hear ya, it looks bad, but a lot of the times, unfortunately, in this area, it's not what you know, it's what you can prove to the legal burden. And that's where that shortfall comes in.
What is the process like if somebody suspects some, wrongdoing or something like that from whoever the executor is, whether it's a sibling or whatnot? What is their recourse? What are the legal tools they have available?
Depending on what it is, if it's already an open probate and the court is involved, it's very easy to file in basically a petition that says, hey, we're asking the court to remove them or correct an action, depending on what's going on. As I mentioned before, the courts will give people an opportunity to fix their actions prior to just straight up removing them. So if it's super egregious, it's been going on for months and months, the attorney may make the decision to go ahead and ask for the removal preemptively and basically throw that in. So that's something that the attorney would discuss with somebody. Now, if this is a trust administration, which is done outside of the courts in Arizona, there's no court oversight, then it would look something like typically a demand letter, which is a formal letter from the law firm that says, hey, we understand you've taken these actions. You're not allowed to take these actions. We strongly suggest that you consult with your counsel if you have one, or get counsel to make this, make this process smoother. If they ignore us and kind of continue, then that's where we would file a petition and basically open a court matter to say, hey, we need to get this person out of this position. They're ignoring us. They're not engaging legal counsel. Because at that point, the courts will give them some slack, but when it's brought to their attention and they refuse to get counsel, the court has a very dim view on those actions, because it's like, hey, you were warned, you were kind of told, and you basically did not seek to correct or get information. The I didn't know excuse doesn't really work at that point.
Yeah. Wow. So, I mean, you're not a therapist. Well, I don't think you're a therapist.
Well, not on paper.
Not on paper, but that was going to be my question. I mean, do you find yourself often having to, kind of help coach people on separating emotion from legal strategy?
Yes, that is a very large part of specifically my job as the paralegal. So I am the one that talks to the clients the most as the paralegal. I'm kind of the conduit for Elizabeth or the other attorneys in the firm, to relay information or say, here's our next step, or explain things. Now, if it's something I can't answer or do, then they do go on the attorney's calendars. But typically the paralegal in most firms is kind of your first line of defense and communication. I would say probably 50 to 60% of the conversations that I have, especially with clients in the beginning or newer clients, it's really not legal centered. It is, I understand that happened. I'm really sorry. I know this is hard. Your sibling just went into the house and emptied it and you hadn't even had the funeral. You're right. That's morally wrong. Here's what we can do now. And so I find myself having those conversations with people and basically kind of hand-holding them like, it's going to be okay. Here's the plan. Here's what we can address. I'm sorry, but a lot of this stuff, unfortunately, there's not really a legal mechanism to address it. And so I do find that people come in, not necessarily in a bad way, but they're kind of looking for their pound of flesh. Mm-hmm. And they don't understand that the court system is slow. And the probate court's opinion when somebody has passed away is, and it sounds really, really bad, but the court's opinion is it's just stuff. So there's no emergency. And that's really hard for people to grasp, because it's like, no, this is my family. This is wrong. Why won't they do something? And it's like, unfortunately, the court just sees it as things and money and stuff. And none of that constitutes an emergency in their eyes. So trying to get people to understand the difference is pretty difficult. Rightfully so.
Yeah.
Rightfully so.
Well, I see both sides. Like, I see why the court has to do that, right? They can't get involved in emotional kind of, tensions or anything like that. But on the flip side, you do understand why the kids, the surviving kids are frustrated and want, justice, the pound of flesh thing, as you said. And it's just, yeah, that's a tricky situation.
Yep. The
Yeah.
other part of that is everybody wants to bring up what happened before. Well,
Mhm.
10 years ago, 5 years ago, and it's like we've got to keep it from basically date of passing forward. The court is not interested. But it goes
Mhm.
to who they are. It goes to the situation. I hear you. You're correct. I'm not arguing with you. I'm telling you what the court's going to do. And it's Elizabeth's job, the attorney and other attorneys, that they present it in the best way possible for you to get the most successful outcome. And in order to do that, sometimes we have to leave things out that you think is extremely relevant, but the court does not. And that
Yeah.
is a hard pill to swallow.
I can imagine. What about if someone's named an executor and they really don't want the job? They don't feel up for the job. What kind of advice do you give to someone in that situation?
Well, we definitely tell people it is a job. It's a
Yeah.
crappy job. It's the worst job you'll ever have.
Yeah.
Like, it sucks. And so if somebody doesn't want to do it, we tell them, okay, let's look. Is somebody behind you? Because typically in a will, there's two. There's a first and a second, sometimes a third. So usually we'll go down the line. If you don't want to do it, you can toss it to the next person. That's fine. Nothing says you have to.
Okay.
I have had situations where all three didn't want to. There are people who are licensed fiduciaries in Arizona. This is their job. They step in on these matters where there's no one to serve. Maybe everybody's passed away or can't serve. And so they step in and do the job. So when we run into a situation like that, we kind of go down the line. If nobody wants to do it, then we have a couple of fiduciaries my office is familiar with that we work with quite regularly. And so then we just kind of have them meet with the fiduciary and kind of pick the one they like the best and then proceed from there with getting them appointed, which is just a petition to the court to say nobody wants to do it. They want a fiduciary to do it. Please appoint them. And then we basically go through the process as normal after that.
Okay. Okay. So that's good. At least they have options if they're really stressing out about it. What do you want listeners to know above all else if they feel stuck in a tense probate situation?
Two things I want everybody to hear me on, and just please hear me. Do not wait. Please do not wait 3, 4, 5, 10, 20, 30 years. I've had it. I've had people call me. They died in 93. They died in 95. Okay, I'm sorry. I don't know what you think we're going to do. That
That's
is crazy
yeah.
town. So
Wow.
I would tell people, if you have a bad feeling, get a consultation with an attorney to talk about what's going on sooner rather than later. There are limitations statutorily for when you can bring a claim. And that's something that the attorney can talk to you about, because it does depend on if it's a will, if it's a trust, did you get notice? There's some intricacies there. So I would say if you've got a bad feeling, speak with an attorney. And if they tell you, give it 6 months, if nothing happens, call me back, listen. But at least you've got the information and you know
Right.
what your next steps are. Don't wait. The second piece that I want to tell people is when your attorney tells you it hasn't been enough time for you to basically, bring in action. The other problem I see is people will act too quickly. Well, my mom died 2 weeks ago and they haven't sent me anything. Okay, you guys are all grieving. Can we give everybody a little space here?
Mhm.
So there is, two sides to this coin. And so I would just tell people, if an attorney tells you you need to wait a little bit longer, you need to just hold on. It's not reasonable. Please hear them, because they are trying to make sure that you're protected, because if you come in way too hot, it's going to give you another problem. You're going to look unreasonable. And so we don't want that either. So those are the two things that I would tell people is just common sense, take a breath, and speak to an attorney so they can kind of let you know what your options are.
There's a term in sports, trust the process, and I think that's kind of what you're getting at, right? There's a process here, just trust in it and try to be patient.
Yep.
Yeah. I think that's great advice. All right. Well, thanks for listening to Probate Problems and Practical Solutions. If your family is dealing with a difficult probate or an untrustworthy executor, visit copperwrenlaw.com to find help and clarity. As always, please be sure to subscribe to our channel, leave us a review so you don't miss another episode. We really appreciate you being here. I really appreciate your time, Carly. It was great chatting with you. Thanks so much.
Thank you. You too.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.